No pervy wanker he. Our next speaker is Ellis Murov of Deutsch Kerrigan Stiles in New Orleans. Ellis has taught labor law at Loyola University Law School, is an employment disputes arbitrator for AAA, has served as chair of the Employer-Employee Relations Committee of TIPS, and is a member of the board of editors of the Tort, Trial, and Insurance Practice Law Journal. Ellis is the head of his firm's labor and employment law section. He's a Louisiana super lawyer and has been voted each year to the list of best lawyers in America in the labor and employment area since 2007. Presenting on the convergence of ethics and bad faith, please welcome the network's other Ellis, Ellis Murov.
Thank you very much. Thank you for being here today. We're going to talk about a number of rules of professional responsibility in the context of a case. And when I say a case, I mean a case that goes back to 1980. Some aspects of it are still going on today. So let's start in 1980 when the St. Tammany Parish Sheriff's Office had a liability policy with American Druggist. It's a 3-year policy. For some reason, the first year there was only $100,000. The next 2 years, 81, 82, 82, 83, there was $1 million. In 1980, Douglas Frierson was found murdered in St. Tammany Parish, and so the sheriff assigns Mr. Gary Eugene Hale to investigate the murder. He does, and he arrests Mr. Burge. Not too long later, the DA dismisses the claims against Mr. Burge, and he's released. About 4 months later, Detective Hale marries Glenda Frierson. That's the sister of the deceased. Time goes on. About 3 or 4 years later, Mr. Burge is in prison in Mississippi when supposedly one of his cellmates hears him confess to the murder of Mr. Frierson, so he's rearrested. At this time, the sheriff's office had a different insurer. It was Southern American Insurance Company, still $1 million. And Burge is sent back to Covington, St. Tammany Parish, to be where he's going to be tried, and was in fact tried in 1986 when, by the way, we have another insurer, if you will. The sheriff is now self-insured. And in 1986, Mr. Burge is convicted of first-degree murder, sent to the state penitentiary for life, and there's more to the story, of course. In the next couple of years, American Druggist and Southern American went bankrupt. And in 1991, somehow it was learned or alleged that exculpatory evidence had been withheld. And so Mr. Burge was given a new trial. Well, he sued, before he even gets his new trial, he sued everybody. Detective Hale, anyone who ever came near the case in the sheriff's office or the DA's office. Okay. Louisiana is a direct action state. Not too many of those. That means you can sue the insurer directly. So, of course, he would have sued American Druggists, except he can't sue American Druggists. They don't exist anymore. But there happened to be a reinsurance treaty between American Druggist and Northwestern National, so he sues Northwestern National. And he would sue Southern American, except that they don't exist anymore, but he can sue the Louisiana Insurance Guarantee Association or LIGA. He sues LIGA. And of course he sues the sheriff, but now the sheriff, ironically, is a defendant wearing a couple of hats. He's a defendant with an insurance company, Northwestern, LIGA, and he's defendant on his own for a period when he didn't have insurance. Oh, by the way, the allegation against Mr. Hale was after the trial where Burge was convicted, he shows someone, by the way, I've got this stuff in my trunk and it would have helped Burge. Well, anyway. So, Northwestern is served. What do you do if you're an insurance company and you pick up a case like this? They have no file. They have no claims file. They have no underwriting file. They have nothing. But they're defendant, so they go to the Ohio liquidator, find the policy, hire a lawyer in New Orleans, deny coverage, and it stays that way for a while until they say, you know, maybe what we should do, maybe we should defend under reservation of rights. So they said, well, here's what we should do. Our lawyers in New Orleans have already learned the case. They know the issues, and it's kind of long and windy. The insureds, the sheriff and Detective Hale, would benefit from this from getting a new lawyer. So we're going to have you, who were representing Northwestern, now represent the insureds. Northwestern's going to get another lawyer to represent it as coverage counsel. Well, the defense counsel now, was former coverage counsel, meet with Hale. And Hale is not your everyday client. He says, look, I'll be there for trial. Let me know. I don't want to settle the case. I don't want to get updates. Just let me know. Hale moved around a lot. He was afraid. He still believed that a murderer was on the loose and could go after him. So another attorney becomes coverage counsel. The sheriff, of course, has yet counsel. They have defense counsel, but for the time period where they had no insurance, so they have their own lawyer. Fast forward into, say, 97. I'll get you to there as fast as I can, and then we'll start looking at some rules. 97, you have motions for summary judgment. You have Northwestern filing one, you have the insureds filing one, and you have the sheriff filing one. Well, the sheriff opposes Northwestern's motion. The insureds do not oppose Northwestern's motion, and it doesn't seem to matter, except you'll see it kind of does a little bit, because the motions were denied. So by the end of the summer of 2000, here's where things stood. There had been a lot of discovery submitted to the sheriff's office saying, by the way, give me all your insurance, and by the way, particularly like the insurance that shows you have $1 million of coverage rather than $100,000 with a $50,000 deductible. Sheriff says, no, it's just $100,000 with a $50,000 deductible. Burge tries to settle the case for $800,000. Northwestern says no. For $725,000, Northwestern says no. For $400,000, Northwestern says no. Defense counsel and coverage counsel then write identical 10-page letters to Northwestern. Among other things, they both say there is some evidence that Lincoln National may have had $900,000 of excess insurance, but of course that can't be right because the sheriff said that's not right. And they talk about ways that Northwestern can settle the case and get out of having to defend this expensive case that's been going on for them for about 7 years. LIGA pays their statutory limits. Defense counsel does a nice job of negotiating a settlement. It's $75,000, and think about this, that's essentially $25,000 more than Northwestern believed its policy limits to be, 100 less 50, plus 25 is 75. The release they get is a little interesting, because Northwestern gets a complete release for itself, for Hale, for the sheriff, for the 1980-1983 time period. Nothing for 83 to 86, nothing for 86 beyond. Why? We didn't insure them then. And Burge reserves his rights to go after anyone for punitive damages for any time period, which is fine because punitive damages weren't covered, but reserves his right to go after Hale and the sheriff for 83 and beyond and 86 and beyond. And Northwestern does one other thing. It says, you know, given all it's done, and it's paying well more than policy limit, they want Hale to release it from its obligations if there were any other obligations going forward. The law firm then urges Hale to get another lawyer, withdraws from the case, and gets the judge to continue the trial because he needs time to get Hale to get another lawyer. Case goes to trial. Hale represents himself, the sheriff has a lawyer, and the jury returns a verdict of $4 million. In and of itself, that may not be too surprising if you think about some of the equities, but the kicker here is the jury form has, 3 lines and some little spaces beyond it. Are you liability or not? 1980, 83, 1983, 1986, 1986 and forward. Jury just says $4 million. Doesn't distinguish any time periods. Where does the release come in? Well, apparently it didn't matter. It's $4 million, and it didn't matter until Hale doesn't appeal. He doesn't have any money anyway. The sheriff appeals. They have money, and it's reversed. So now Burge goes to Hale and says, look, I'll be good to you, but I want you to sue your lawyers and your insurer. Hale says, no. He says, fine. Puts him in involuntary bankruptcy. So you have the bankruptcy estate of Gary Eugene Hale, who's got one creditor, Gerald Burge, and the trustee then sues the defense counsel for malpractice, then sues the insurer for bad faith and for some concept of they're also liable somehow for the misdeeds of the law firm, like a vicarious liability. In 2004, the trustee discovers, in fact, that there was another $900,000 of insurance through Lincoln. sues Lincoln. Lincoln gets out on summary judgment because it's kind of late, like notice, prescribed, untimely. That's the one aspect of the case that's actually still going on, because Byrd sued Lincoln on his own in state court, where they have different rules. They apply one law in state court and one law in federal court. Anybody ever heard that one? Yeah. Hale gives a deposition and says the law firm didn't send him contemporaneous, communications about the case. Of course, he didn't want any. It says the law firm didn't adequately explain the release with Mr. Byrd, much less the release that he was given to Northwestern. He thought his only exposure at trial was for punitive damages. And, by the way, the jury did not award punitive damages. He signs this release of the insurance company, said the law firm, defense counsel sent this to the courier, said sign this. He said fine. Carefully read the release. He didn't get the law firm's files before he goes to trial. And now we're almost there, folks. Actually, y'all are listening. I'm pleased. 2007, we're in the Fifth Circuit again. This is the fifth time the case has been there in one form or variation or another. And Mr. Byrd, the trustee is the appellant, because the district judge had summarily dismissed the claims against the trustee and granted judgment in favor of Northwestern and defense counsel, and the Fifth Circuit reverses and says there are disputed material facts as to the amount of coverage, policy limits, years of coverage, whether, in fact, Hale could knowingly and voluntarily do what he did if he didn't understand the releases, and so forth. So, with that in mind, let's start looking at some of the rules we have that apply to this case. Rule 1.7a is pretty simple, and it says, except as provided in paragraph B, a lawyer shall not represent a client if it involves concurrent conflict of interest, which means there could be one client being adverse to another. Well, let's think about that. If the sheriff says, Mr. Hale, you left my employ in 1981. In 1986, there's this trial and where it's alleged you withheld exculpatory evidences in your trunk. Why should I pay for that? So the sheriff's not willing to waive that as a defense. So can one lawyer represent both Hale and the sheriff's office? You would think no, but you have 3 policy periods. And in the 1980-83 time frame, supposedly Hale had withheld nothing. The case is not tried to 86. Can one lawyer represent both of them? They never resolve that issue, but you're going to see as we go through a few of these, and I have to go fast, and I'm trying to go fast and talk fast. The trustee's idea was that they wanted to show that ultimately the defense counsel never really stopped representing Northwestern and never really represented Hale. So let's look at the next rule. A lawyer who has formally represented a client in a matter can't represent another whose interests are adverse unless there is consent. Well, who's the former client? The insurance company. Did they consent to defense counsel representing the insureds? Sure. Was it in writing? Well, it wasn't, but that wasn't a big deal. I mean, what's the real harm there? And let's look at Rule 1.1. It says a lawyer shall provide competent representation. Well, everyone knows that. That's axiomatic. Well, the question is, folks, if you have a conflict of interest, can you be providing competent counsel? And there are cases that say, well, maybe not, actually. And remember what the trustee is trying to do here. So let's look at another rule. 1.2c. A lawyer may limit the scope of his representation if it's reasonable and the insured consents. Perfectly normal, everyone understands it. Well, how about this one? If the trustee took the position that defense counsel should have opposed Northwestern's summary judgment motion on coverage, and defense counsel said, don't be silly, nobody does that. It's custom and practice. The insurer doesn't pay defense counsel to fight it on coverage. Everyone agrees with that. Trustee and their legal expert said, well, yeah, that's all true, but you still have to go to Mr. Hale and explain to Mr. Hale you can't oppose Northwestern's motion. If you want to oppose, you've got to get someone else. Hale said that never happened. Okay. 1.3, this one makes perfect sense also. A lawyer shall act with a reasonable diligence and promptness when representing a client. Okay. Well, how about this? Case law in Louisiana says the insurer has no duty to find excess coverage. It's not his problem. What about the lawyer? Does the lawyer have a duty to find excess coverage? You bet. Did the lawyer try to do that? Absolutely. Did the lawyer succeed in doing it? Well, the lawyer was told by the sheriff's counsel there's no more coverage. In fact, there was. Question was, should Lincoln have nevertheless been placed on placed on notice about a potential claim? Well, they didn't do that. The trustee cites a case out of New York where, in fact, that issue came up, but by the time the lawyer did it, it was untimely. And back to the one point, the previous one, whatever it was, said also the lawyer has to establish with the insured whether he's going to go after and deal with the excess. Whether the scope of his representation includes going after excess coverage. Well, in this case, they tried, but they never talked to Hale about it. Remember, Mr. Hale didn't want to be bothered with details like what the heck is going on in the case. Which gets us to, wrong one, the meat of the case. And I'm sorry it takes us long to get to the meat, but it's useful to build these things up. 1.4, a lawyer shall keep the client reasonably informed about the status of a matter, and 1.4b shall give the client sufficient information to participate intelligently in decisions concerning the case. Well, here's how it comes down. The trustee says, lawyers, you guys were supposed to tell Mr. Hale about the offers to settle. And they said, well, we didn't. He didn't want to know. And they said, yeah, but that was really material because someone could have lit the fire under Northwestern to pay more than policy limits. By the way, they paid that anyway. And get a complete release, not just a release for the policy period 80 to 83. And a lawyer who's truly representing Mr. Hale would have done that. And also, Hale doesn't have any money. Hale doesn't need a settlement for just 80 to 83. He either needs a complete release or a lawyer at trial. Well, they got out of the case. Well, here's one thing we know for sure. In Louisiana, and I'm sure everywhere else, if you don't tell your client about settlement offers, you're violating the rules of professional responsibility in your case. B, insurers, in fact, can be held liable for the same thing if they don't tell the insured about settlement offers, and it would have made a difference, like, say, the insurer would have come up with a few extra bucks. The insurer is now liable for the bad faith. On the other hand, even if you had told the insured about the offers and the insured didn't want to pay the guy anyway a dime, well, it's immaterial. All right, I know I'm out of time. Let me see if I can hurry through one or two quick ones here. Let's talk about this. And how does a client knowingly and voluntarily agree to a settlement, consent, whatever, if you haven't talked to the client except, by the way, after 5 years, we need to talk about settlement, come on in. These lawyers, and they're good lawyers, and I have nothing, I'm not critical of them, I don't think they did anything wrong, but think about it. If you've been talking with your client for 5 years, and so that when you now sit down and talk about settlement of the case, you don't have to go through a lot of things. In fact, a lot of things you may have forgotten, you may not even think were important for purposes of the settlement because the client already knows them, but you do this in one or 2 hours. Does that work? And what kind of client, do you fire your client, folks? I've done that before. I suspect some of y'all have at some point in time. But how do you fire a client? You say you're not cooperating. Well, you tell that to the insurer and mess up coverage. You don't want to do that. That's going to be its own ethical violation. How do you represent a client that doesn't really want to play because, by the way, he's afraid of moving around because he's afraid he's going to be killed? I'm over time. There's some other, out of time. There's some other information in the materials. Y'all been very kind and attentive. I appreciate your attention.